Yes, I would love some. Actually, I'd
As he said, we saved the most exciting topic for last, antitrust class actions. Today we're going to be talking about two-sided markets in antitrust class actions. I am Leah Nylen. I am the Chief Global Antitrust Correspondent for MLex, which is a very fancy way of saying that I'm a journalist, and I write about antitrust cases. I'm going to do a brief, just a really brief introduction of all of our panelists. Darryl Anderson is a partner at Norton in Houston, and he specializes in antitrust and competition litigation. Mark Rifkin is a senior partner at Wolf, Haldenstein, Adler, Freeman, and Herz in New York. He's an experienced securities class action and shareholder rights trial litigator, and for the purposes of this panel, he represents a class of Apple iPhone owners who are suing Apple over its App Store in a case that is currently pending at the Supreme Court. And David Kaplan, to my left, is Executive Director and Vice Chairman at BRG in Washington, D.C. He specializes in antitrust economics, particularly price fixing and monopolization cases. So just to get us started off, David, can you talk a little bit about what is a two-sided market?
Just by way of introduction, economists think about markets in the following way with respect to the concept of two-sided markets, where you're bringing together two different constituencies that largely would have interest in common and potentially perceived differences that might be different. And the best way to describe this is to give you a few examples. And the first one I'll use is an old one, which is newspapers. A newspaper is interested in two things: one, subscribers, and advertising revenues. And from an economic perspective, that provision of services is described as having two sides: subscribers and then advertisers. And you might well imagine, of course, that the newspaper wants more subscribers, and the advertisers also want more subscribers, so there is a coterminous interest between those parties. On the other hand, if the newspaper decides to lower subscription rates and then says to advertisers, we're going to pay you less, you can imagine a circumstance in which the advertisers might feel that their interests are not necessarily aligned with the subscribers. And those are the two sides of thinking about newspapers. To bring it more current, of course, Facebook is the perfect example of a modern division of two sides where you have, again, advertisers and, if you will, subscribers or users of the social platform. In addition to that, of course, American Express, all of you who have paid attention to the recent Supreme Court decision, where American Express is interested in obviously providing credit cards to consumers, but also interested in having those cards used by merchants. Again, two sides, consumers and merchants, that may well have interests in common. Uber is another perfect example. What are the two sides? Drivers and folks that utilize the service. They're two sides of, if you will, the same market. And I don't mean that in an antitrust sense, but in thinking about the economics that facilitate decision-making with respect to Uber. Uber is making decisions that they hope will maximize the benefits of both sides of that market. And just to leave with one last one, and I say this with some trepidation given that Mark is on the panel, one can think about Apple as functioning with two sides, app developers and, of course, individuals that are part of the ecosystem. And I understand that's an issue of some debate. Two buzzwords here that are critically important. One, when thinking about thinking about two-sided markets, think about the word network, which is that people who function in markets that have two sides want to expand the size of the user base. And then secondly, the other word is balance, and that is the people making decisions. Zuckerberg, the CEO of Uber, CEO of American Express, they're looking for ways to balance the interests of the two sides of these different markets.
Okay, thank you, David. So as he mentioned, this is not necessarily a new topic, but it has come up a lot recently in antitrust law, particularly the American Express case that Darryl is going to give us a brief overview of.
Sure. So, just almost a year ago, the Supreme Court waded into this issue of two-sided markets in the Amex case, which was a case brought by federal and state governments challenging Amex's anti-steering provisions. So these were provisions where Amex would say to the merchants that were accepting an Amex card, at the point of sale, you can't tell your customer who's about to make a purchase with his Amex card, hey, I realize that you've got an Amex, but they charge me more than Visa does. If you would use your Visa card, I can cut the price $1, we'll all be better off. So anti-steering provisions prohibited that type of behavior from the merchants. And the challenge was that was an anti-competitive action done to preserve Amex's higher fees that they charge to the merchants. So there was a 7-week bench trial in the trial court, which ultimately concluded that it was anti-competitive. And that went up on appeal, ultimately getting to the U.S. Supreme Court. And the issue there was whether the plaintiff had established the anti-competitive effects due to these anti-steering provisions. And it was a 5-4 decision, kind of the usual breakdown that we hear about, with Justice Thomas writing the opinion. And he focused on this two-sided platform. So in the trial court, the conclusion had been, the findings had been that there was a market for providing processing services to merchants, that the merchants were injured because they paid higher fees, sort of what you would think of as a standard antitrust analysis. And the Supreme Court said, you've sort of missed the bigger picture, that this is a two-sided market. And so you have to consider both sides of the market in doing your antitrust analysis. So what the court said was they're both part of a single market for transactions. Courts must include both sides of the platform, merchants and cardholders, when defining the credit card market. So the two-sided platform that David was talking about gets imposed into the antitrust concept of a relevant market here and says the relevant market has to be defined to include both sides. So as a result, the Supreme Court reversed the trial court, saying it made basically 2 errors. First of all, it had defined the market incorrectly by focusing only on one side of the market, and that then led to a misunderstanding, in the Supreme Court's view, of anti-competitive effects, because by just focusing on the fee charged to the merchant, according to the Supreme Court, that ignored the benefits that come on the other side to the cardholder. You have to look at the overall price of the transaction in the way that the Supreme Court thought about it, because, and the quote that I thought was effective on that was, price increases on one side of the platform do not suggest anti-competitive effects without some evidence that they have increased the overall cost of the platform services. So pulling it back to antitrust, on this question of are there anti-competitive effects here, just looking at the higher price charged to the merchants was not going to be sufficient because of the two-sided nature of this market. You had to look at the overall price, and that was the ultimate conclusion I think that's relevant to us today.
Great. So the big question post-Amex is exactly how far does it go? So the Supreme Court's decision refers to two-sided transaction platforms, and some folks in the Justice Department and FTC have tried to suggest that that's a very narrow definition, that this is only going to apply to things in which there is a transaction, a simultaneous transaction. Do you think that's fair?
Well, I think it's unfair to try to label all different market circumstances with a particular label like simultaneity and decide that the simultaneity of the transaction is outcome determinative of whether you're going to conclude that two different sides of a particular industry are part of the same antitrust market. I understand the logic behind focusing on simultaneity, and what I mean by that is that the transaction taking place, i.e. between the customer using the card and the merchant accepting the card, is happening literally temporally at the same time. Although I think that's relevant, I don't think it should be outcome determinative, because there could well be situations, and again, I know Mark is going to comment on this. Apple is an example where they might be dealing with app developers at a particular point in time, and separately thinking about and worrying about increasing the usage of their phones taking place at a somewhat different period of time, but nevertheless, the decisions that Apple might be making, arguably, are ones that are designed to generate the best outcome for both sides of that market, even though you don't have the same simultaneity that you might have, for example, in American Express, or again, in the Uber situation, where you have consumers literally paying the drivers and the drivers making money simultaneously at the same time.
Mark, do you have thoughts?
I do have some thoughts on Amex, and particularly as it relates to the very narrow issue which is now before the Supreme Court in the Apple versus Pepper case, which is whether consumers who buy apps on the App Store platform, where they're forced to shop by virtue of Apple's complete control of the iPhone, whether they have standing under Illinois BRIC to sue Apple for antitrust violations. I think the Supreme Court's decision in Amex has a giant inconsistency in it that relates directly to that. And if I can, I'll read to you two very short passages from the majority decision. Early on in the opinion, Justice Thomas writes, a two-sided platform offers different products or services to two different groups who both depend on the platform to intermediate between them. And I want to emphasize different products or services. I don't think there's any dispute that Justice Thomas and the majority conclude that the Amex market is a two-sided market. But with that definition in mind, he then writes later on in the opinion that credit card companies such as Amex are best understood as supplying only one product, transactions, which is jointly consumed by a cardholder and a merchant. Now, one might conclude, having heard nothing other than that Justice Thomas would write for the majority that the Amex platform is not a two-sided market. Newspapers who sell advertising to advertisers also sell content, not advertising, to readers. Two different products offered to two different markets. So if we think of newspapers as the quintessential two-sided market, we would conclude that Amex is not a two-sided market, but obviously the majority differed. It is a profound question for the standing of the plaintiff class, the consumers in Apple, which I'll discuss in a little bit. Or would you like me to do that now? You want to talk a little bit about Apple? Or?
Did you have any more thoughts on Amex?
Well, I guess the only thing I would say is I agree that that's sort of the looming question out of Amex is when does a two-sided market constitute a single market, and when is it more typically thought of as two different markets? And as I read the opinion, there are a couple of factors that the court is emphasizing. One is the simultaneity that you mentioned. I mean, they say the key feature of transaction platforms is that they cannot make a sale to one side of the platform without simultaneously making a sale to the other. So I think simultaneity is something that you're going to see courts looking at and trying to decide this in the future. And the other is these indirect network effects that David talked about at the outset. The court actually, when describing those, called them most relevant. So, I mean, I would focus on that as well. And that point is the value of the services that a two-sided platform provides increases as the number of participants on both sides of the platform increases. So two-sided platforms must be sensitive to the prices that they charge on each side. So this idea that you may be getting price pressure on one side based on something that's happening on the other side, and therefore that requires you to consider both sides. And so I think, it is the open question as to how this is going to be interpreted, but I think you're going to see a lot of focus on those two factors in trying to navigate that. And of course, the court talks about the newspaper example, and I think indicates that the network effects there are not perceived to be as large in that context as they are in the transaction platform. And you can agree or disagree with the economics of that, but I think that's the distinction they're trying to make there.
Lee, can I make one other
Yeah.
point? Mark makes an important point in thinking about the concept of market definition in the context of Amex and in Apple. And I'm not going to discount the relevance of defining markets. But I will say that thinking about overall competitive effects, to me, is more important than necessarily the precise definition of the market. I know they're intertwined and interrelated, but as I think about economic consequences of decisions being made by actors in markets that have two sides, the issue that seems most important to me is the overall competitive effects of those actions in terms of consumer welfare.
So I didn't put this exactly in our questions, but do you think this applies equally? We were talking about simultaneous transaction platforms, like you could think of Uber, Airbnb, the App Store, arguably. And then there are other types of two-sided markets in which half of it is free, like Facebook and Google. How do we think this may apply to that?
Well, I guess I think, the court pretty clearly indicated that you might have zero prices or much lower prices on one side as compared to the other. So I think just because it's free doesn't mean you're not going to be in a two-sided market. I think you could very well still be in a two-sided market in that context.
Okay, great. So how is this going to apply to class actions?
Well, so let me put this in the context of Apple in a concrete context. So the question before the court on Apple is, as I said, whether consumers are direct purchasers with standing under Illinois BRIC. Historically, Illinois BRIC has been applied in a very wooden, very strict, very literal sense. Who buys from the monopolist or who sells to the monopolist, it doesn't matter. And if you are the first in line from the monopolist and there's nobody between you, then you have standing. And the courts have gone so far as to say, even if everybody agrees that the first purchaser keeps none of the overcharge itself, but passes all of it on, that's why I didn't want to pour the vodka, passes all of it on to the second purchaser in line, we're still going to stop at the first purchaser, and only it has standing to sue. So come along, Apple, and there's no dispute that consumers buy directly from the monopolist. It's impossible to dispute that. That's the fact. But Apple says, yes, but it relates to a prior agreement we have with app developers, and that's the only reason why the prices are charged the way they are. But let me explain the way Apple works so that we have a better understanding of how it fits into the framework. Apple, without calling it a two-sided market or not, I don't know whether it is, Apple sells two distinct products to two distinct markets. Upstream, it sells distribution services to apps developers, and downstream, it sells apps to consumers. And it forces distribution services on the apps developers by virtue of its complete power over the iPhone. If you want to put an app on an iPhone, the only way you can do it is to sell through Apple. And downstream, it forces consumers to buy apps only from Apple. If you want to put an app on your iPhone, the only way you can do it is to shop on the App Store. So the question then becomes, for a class action or an individual action or any kind, it's who has the ability to bring the lawsuit. Does it belong to the consumers or does it belong to the developers? And what we say is it distorts both of those markets, but in slightly different ways. Consumers pay more for their apps. Apple charges a 30% markup on all the apps, number one. And number two, it also requires app developers to set the price for an app at a price that ends in 99 cents. So you can charge 99 cents, you can charge $1.99, you can charge $2.99 or $10.99. But what you can't do is you can't charge 90 cents for an app. So if a developer says, my competitive maximizing price, the price at which my profit will be maximized, is 90 cents, because at that point, I will sell enough product to overcome the 9 cents I'm giving up in the price. My profit maximizing price is 90 cents. Apple says, nope, can't do it. So that developer is losing sales. The consumer who buys that same product pays 99 cents for a product that he should have been able to buy for 90 cents. So he or she's suffering a 9 cent per app purchase injury. That's really easy to figure out. On the consumer side, it's It's the extra cost, the increased cost over the competitive market price for the app. And that's our theory, period, end of discussion. On the developer side, it's a little more important because, among other things, you have to consider the number of sales that would be made at 99 cents and the revenue that would be earned there, minus the number of sales that would be made at the 90-cent price and the revenue that would be earned there. Now, apps are unique because there's really no marginal cost for an app. Once you've developed an app, it doesn't matter if you sell one of them or 100 of them or 100 million of them. All you need is a little more bandwidth to sell 100 million of them, but Apple's giving you the bandwidth. So you can sell all you want. You know, you give Apple the product, essentially, and Apple will sell all of it can. And those theories are slightly different. The harm is slightly different and the theories are slightly different. So I think that there are two different markets here that may or may not be actually occurring simultaneously. I don't know whether they do or they don't because I don't think that Apple remits the price to the developer immediately. It doesn't go from consumer to developer. It goes from consumer to Apple and then ultimately to developer. And I don't believe those transactions are instantaneous, but I won't comment on that because I'm really not sure. So we had two amicus briefs submitted that I'll comment on because I think they're extraordinary. The first is 31 separate state attorneys general filed an amicus brief on our behalf saying this notion that Apple doesn't sell directly to consumers is ridiculous. And what we found interesting about it was that it was led by a Republican AG from Texas and joined in by Republican AGs all across the country and also Democratic AGs, for example, from California, from New York, from Illinois, ironically from the state that gave us Illinois brick. But a really extraordinary coalition of AGs across the aisle. And then even more important than that, 18 antitrust scholars filed a brief on our behalf and said to the court that the fact is there are two distinct markets here and there are two distinct injuries that are suffered by two distinct market participants, the developers and the consumers. And the antitrust experts, including the father of modern antitrust theory, Herbert Hovenkamp, they say the Supreme Court has never ruled on the question whether in a structure like that there's only one direct purchaser. There may be more than one direct purchaser in a market that's structured like the app market with the iPhone, and they cite a number of instances where the lower courts have allowed distinct participants, different participants, in what we would otherwise think of as the same market if we really thought about it a little bit and looked more closely at the structure like we have at the App Store structure, where those different market participants have been allowed to bring direct purchaser claims against the same alleged monopolist upstream and downstream. And that's what I think we have going on in Apple. I think Apple insinuates itself in what would otherwise be a direct transaction between developers and consumers, and it put itself in the middle there so that it can extract its 30% charge. It's indifferent where the money goes. It's indifferent where the money comes from. All it wants is a lot of sales because that's how it makes billions of dollars a year, is by selling a lot of those apps. So that puts the theoretical issue of Amex and the two-sided market structure and the real-world economic issues of how do we look at what damages are and what injury is to a focus, because we have the unique structure of two different participants upstream and downstream with two decidedly different kinds of claims and two decidedly different injuries.
Yeah, let me preface this comment by saying that I have never worked for Apple and I don't work for Apple. Just a couple of brief comments, and then I want to try to bring this into the class action context more directly, which is number one, I'm sure that Mr. Cook would disagree vehemently that Apple's a monopolist, given that the phones that they sell represent about 20% of smartphones, with Google Android bases having a much larger share. And secondly, going back to the point I made before about consumer welfare, I'm not going to quarrel with any of the statistics that Mark's articulated. He knows them better than I. I don't have a comment one way or another about the mechanics of it. The only point I would make is that one could argue that the decisions that Apple is making are in the best interests from a consumer welfare standpoint because they're enhancing the number of people who write apps and they're enhancing the value of those apps to consumers. And that would be a counter response. But on the class action issue, just very quickly, let me just talk about Uber because it's easier, I think, to understand, at least from my vantage point. Assume the drivers bring a lawsuit against Uber claiming that their wages are too low. In a traditional class action context, what we would do is we'd say, well, they're arguing their wages are too low, and what's the but-for world? The but-for world is their wages are higher, and we're going to measure the difference between those two as a form of antitrust injury. But maybe the reason that their wages are low is because Uber is charging relatively low prices to the people who use the Uber services. And because of those low prices, it is true that the wages they earn are lower, but the number of rides that they develop are significantly higher. So from a class action standpoint, from the issue of impact and damages, I would argue it's not sufficient to simply look at the difference in wages, but you also have to take into consideration the two-sided market context in that they may have benefited because riders, the other side, have used their services to a greater extent, and from an economic standpoint, they may not have suffered injury. And it's in that context that I think this two-sided market issue has a dramatic effect and will have on class action definition going forward.
If I can respond briefly, first I want to be clear that the relevant market in the iPhone case is not, and I don't think David meant to characterize it this way, it's not the market for smartphones. We've been fighting this battle with Apple since 2007. Apple has been saying it doesn't have, it never had, and it never will have monopoly power in the iPhone or smartphone market. Big deal, so what? The relevant market is what is known in the antitrust literature as an aftermarket, and it's the market for iPhone applications. And in that market, the only place you can buy an app for an iPhone is the App Store. They don't have monopoly power. They have perfect monopoly power. And every time they say, we're not a monopolist, I chuckle, because they can try to define the market however they want, but since we're the ones who actually made the claim, ours is the market definition that will count. Bless you. As far as David's observation about the class issue is concerned, I agree with him wholeheartedly. The class definition and the market definition in antitrust class actions are really one and the same. We define the class by reference to the relevant market and put some date parameters around it. That's it. And if we were to define the market, looking at it from the standpoint of apps developers, which are akin to the drivers in the Uber case, I would agree 100% that we would not just simply look at the price, but also at the volume. Because a profit maximizing participant in an open economy may charge a lower price and earn more profit at the end of the day, particularly when your marginal cost is zero. All you want to do is sell proportionately more at 90 cents than you can at 99 cents, and you'll sell 90-cent products from now until the cows come home. And Apple won't let you do that. They tell everybody your price has to fit in a particular structure. It's 99 cents or $1.99 or $2.99, so that they take away 99% of the possible prices you can charge for your product. It's that control that potentially harms an app developer, because he may decide to lower his price by 3 cents and sell a bunch more apps. I don't know. That's for the apps developers to look at. For the consumer, it's an easy equation. If you make the app developer raise his price by 1 cent, you've cost me injury. I don't need to do complex math to figure out what my harm is. I'll take the penny. That's it. It's that simple. And when we look at it that way, we can see why these economic issues raise two markets in this transaction. And that's what we hope the court says. And there's a couple of other possibilities, one of which is that they do away with Illinois BRIC altogether. I think that's for another day, but watch for that because it's coming down the road. The other possibility is the court says everybody has standing to bring a claim in a two-sided market. I don't think that's what Justice Thomas had in mind when he wrote American Express, but it may be the implication for that decision. We don't know yet because it wasn't an issue in Amex. Strictly speaking, it's not an issue in Apple either, but we'll see. Who knows what they say. Anyhow.
That was one of my next questions when we were going to talk about who has standing to sue. Do you think it's possible that they might? I
think it's pretty clear in this case that the consumers have standing for the reasons that I've articulated, and the apps developers likewise have standing for a different claim with different injury for this, also for the different reasons I've articulated.
I feel like I should point out the Solicitor General did not agree with you.
Yeah, the Solicitor General of the United States did not agree with us. He agreed with Apple, or I should say the government agrees with Apple, that only apps developers have standing. I think he's missing the point. The Solicitor General's position, and just to elaborate on that, was influenced by the government's view that Apple doesn't set the price, only apps developers set the price. The antitrust experts, the scholars, wrote in their brief, number one, it's not true, and as I told you, it fundamentally isn't true. Apple controls the price and reserves the right to force apps developers to charge any price it wants. In other words, Apple gets to tell app developers anytime it wants to what it can sell its apps for. I think there's joint price setting, but the antitrust scholars also explain in their amicus brief that it shouldn't matter. When you analyze the structure of the market, it shouldn't matter who sets the price because you have these two distinct economic realities going on. You have the developer reality and you have the consumer reality.
Do you have any thoughts?
So the only thing I guess I would add to that is on this question of standing, right? If you look at it as a single market with, to take it back to the facts of Amex, both merchants and cardholders purchasing transaction services, then it's hard for me to see how they wouldn't both potentially have standing, right? I mean, to bring the claim. And in some ways, on that question, it seems to me in Apple, if the court were to find that it was a two-sided market, which I don't know this directly presented, but if it were to make that conclusion, it wouldn't really affect your case as terms of you would still be a direct purchaser, right? I think the complicating factor comes down the line once you make the conclusion that it's a two-sided market as to how you're going to ultimately prove your case, particularly in a class action context, which gets back into the points that David was making about how the individual issues and the difficulties of establishing common impact are going to be exacerbated, I think. And on that, and Mark talked about if you pay 1 cent more for the app, then that's an injury. But I think if you're looking at it from two sides, you're going to confront economists that are making arguments that saying, look, you paid 1 cent more, but you got benefits by virtue of the other side of the market. So if it's the Uber example, you got benefits because there were more drivers available that would not have otherwise been available. And so that's a benefit that is part of the market. And it takes you out of the situation, which comes up in these cases a lot, which you see people argue. You can't argue that a benefit in a different market needs to be compensates for a harm in this market, right? If you've got a harm in one market, that's an antitrust violation. It needs to be remedied. You can't point to a separate market. But once you've concluded that this is a single market, then you have to take that into account. And so it becomes an issue all throughout the life of the case in litigating both liability and class certification, I think.
Great. So what about some of the other issues with class certification, such as adequacy and typicality? How are the two-sided markets might affect that?
Well, again, I think if you look at it on a strict class action sort of analysis, if you consider a two-sided market to be a single market, and you recognize either side as having standing to bring the claim. Let's say that this claim was brought not by consumers but by apps developers. If the apps developers have standing to bring the claim as participants in the two-sided market, how do they represent consumers? Because they have somewhat divergent interests. They have somewhat different claims. They will rely upon, at least at the damages stage, somewhat different evidence and theories of damages. And so I think that you would conclude that an app developer is neither typical nor adequate to represent a single class comprised of all participants in that two-sided market, if you were to say that a two-sided market is one market. I think the solution to that is to recognize that two-sided markets are, at least if you follow the court's paradigm that a two-sided market sells two different services to two different market participants, it really is a two-piece puzzle with two different pieces, each of which should have its own representation.
First, let me give you my deposition answer with respect to issues about
You don't
standing,
recall?
about standing and adequacy, which is that I'm not a lawyer and I don't have any opinion. Again, I think from an economist's perspective, what's critically important, regardless of which party is before the court, if in fact there is a interaction from an economic standpoint between the two sides of the market, so app developers, users, Uber drivers, people who use the service, etc., that any decisions that are made about economic consequences has to take into account both sides of how those markets interact. And that may well lead to very different conclusions, not only about the merits of the claim, i.e., is Apple engaging in activity that is anti-competitive or not, but for purposes of the class action analysis in thinking about how they interact, that the traditional approaches that we've all used for 20 or 30 years in these types of situations where there are two different actors who many times have interests that are coterminous but may have interests that diverge at some point, i.e. the driver versus the consumer of the Uber service, that it's critical for the court to take into consideration the welfare implications of both sides. And I'm going to leave it to the lawyers to figure out how that gets done from a standing and adequacy point of view. I just think it's critically important that the court appreciate those economic consequences when they make their decisions.
Right, and so to put the lawyer point on it, I mean, I think the implication of that is you may have a potential class that has all been overcharged, for instance, but not all of them may have been injured, right? So because some of them may have received benefits that outweighed the costs that they incurred, right? And so you go back to our previous panel, you're in a situation here of how can you show that the class has actually all been injured, or are you sweeping in a bunch of people who actually haven't been injured by the result of that? And that's going to be I think a coming class action difficulty in these cases.
And one other point I'd make, which goes to some of the points that Mark was making about the prices, which again, I don't have any opinion about the mechanics or any of that. But if one were to think about the welfare implications to the consumer, it may not necessarily be restricted only to things that we can measure with a calculator. In other words, is there some utility benefit to consumers associated with the network effects by having more people write apps, et cetera? And from an economist's perspective, we would say absolutely those consumer utility implications are directly relevant. But in a court setting, I could imagine, as we sit here today, I'm not aware of very many courts that are willing to weigh in and try to measure arithmetically, mathematically, how that utility might be offset against an allegedly higher price for purposes of determining antitrust injury and damage. I'm not saying it shouldn't be done, and as an economist, I think it's relevant, but I am raising the issue of of the mechanics might be difficult as we move forward.
So if we accept that there's a single class or a single market that is appropriate here, the real question is, take Apple's monopoly control out of the equation. At what price point would these apps sell? And how does that compare to the price at which they were sold? And if the price at which they would have sold in a competitive environment, the but-for world, would be lower than the price at which they were sold in the monopolized world, then there is antitrust injury to the market participants as a whole, and the question of whether that should be borne by or inure to the benefit of the developers or the consumers or be divided somehow between them is a question of apportionment as opposed to a question of antitrust injury. And that's, I think that's ultimately a question that's suggested by the Apple case in the aftermath of the Amex decision.
We have a couple minutes left. Does anybody have any questions? Jeff.
Yeah, I just had a question related to Apple's pricing. Have they provided any context or any justification for why they require all prices to end in 99 cents? Have they advanced any sort of argument that it leads to efficiency or less consumer confusion, for instance?
No, nor have they provided any justification for their 30% surcharge, which is, by the way, the same surcharge that they charged in the ebooks case. No, they do it because they're Apple.
So the question I want to ask is, how far do we imagine this could go? Because as I'm sitting here and I'm listening to this and I'm thinking about healthcare services. And are we going to start thinking about, okay, there's the price and then there's the access to the providers and you get wrapped up in the quality, and will class actions come down to figuring out the change in utility from all of these other attributes that are conveyed with the good besides the price? And then I'm thinking about how certain states, make you focus on the out-of-pocket expense as opposed to other kinds of changes in utility, and how would all of that work out?
So I have two possible answers for you. One, there was a case that the Justice Department brought down in North Carolina against one of the largest health systems I believe it was in Charlotte. And it was an anti-steering case because the hospital, I guess it was the insurer the hospital had anti-steering contracts with its insurers. They had to refer their patients to their hospital. And immediately after the MX decision came out, they filed a brief saying, we're a two-sided market. And we're all a two-sided market. The court actually ended up not getting to the question because the Justice Department settled the case. But it was going to be the first decision on whether sort of healthcare qualified as a two-sided market. The other thing I'll point you to is the FTC about 2 weeks ago just filed a new complaint against this company called SureScripts. It is the largest e-prescription network in the country. And it's very interesting because they argue in there that it is monopolizing two-sided markets. One of them, both sides.
Yep.
I didn't print it out, but one of them is the market between the physicians and the pharmacies. And the other one is the market between the pharmacies and the PBMs.
PBMs, right.
So that is definitely one to watch this space and sort of see what happens in that case. Okay.
Can I add one thing, Robin? This FTC case that Leah mentioned is particularly interesting to me because the claimed offensive conduct is in both sides of this particular industry/market is lower prices. Is that they've provided lower prices in order to bar competitors. And having spent a large amount of my time in a different matter for a different client where the alleged offensive conduct was consistently providing substantial rebates to particular customers, I find this complaint particularly interesting to see. And let me just say that the courts did not respond favorably to the allegations made by the plaintiffs in the case that I was involved with because they couldn't get past that the offensive conduct was consumer enhancing in terms of welfare. And it'll be interesting to see how the courts react to this particular case, not only on the two-sided issue, but whether the concept of providing lower prices as a form of entry barrier is in and of itself anti-competitive. I think it raises important questions.
So that's good, because it's a good segue to my follow-up, which brings up Walmart. So is Walmart a two-sided market? I mean, so they have all of their suppliers, and they put all the pressure on them for the lower prices, and then they're passing those lower prices on to the consumers. Is that a two-sided market?
I would suggest you read the Breyer's dissent, in which he discusses
Well,
whether.
look, I think the bottom line is there are a lot of two-sided platforms in the world, right, out in the wild, so to speak, and the legal question is which one of those are, for antitrust purposes, necessary to be treated as a single market. And that's really, I think, the big open question that we started with, and that, frankly, there's not a whole lot of guidance in the opinion on, which gives us a lot of room as lawyers and economists to try to craft some standards based on what's going to be enough.
Well, if you like the early part of the opinion where Justice Thomas says it's two different products or services being sold to two different consumers or two different market participants, I think, if Walmart makes a manufacturer sell its products at a reduced price, and it turns around and sells those products to consumers at a reduced price because it gets more favorable treatment, then it's buying one product and it's selling the same product, so it wouldn't fit that definition. If you read farther in the opinion and you put stock in the footnote where Thomas writes, yes, of course, it's the same product transactions, then you say, I don't know, I guess it's a two-sided market, so I don't know.
Yeah, and again, let me start with my deposition answer, which is that I'd want to evaluate the facts of every particular case.
Yeah.
But I would suggest analytically that I think there is something to the concept of a joint ecosystem. And if you think about Uber, and I'll use Facebook and put Apple aside for a moment, that there is a vested interest that is easier to appreciate, understand, and potentially value as the two sides move forward within the ecosystem where there's a mutuality of interest, whether those transactions are simultaneous or not. And I think the Walmart situation is a little more difficult to fit into the same box. I'm not being outcome determinative. I understand Walmart is buying things from people and then selling things to people, and one might say, well, if that's the standard, everything is two-sided. But I do think if one thinks about these other examples that we've discussed today, that there is a mutuality of interest that is stronger and more discernible, which might, as the courts grapple with this issue going forward, might end up being a demarcation. I just don't know.
The real difference is the supplier who sells to Walmart doesn't care if Walmart sells a single one of its products to anybody. As long as Walmart buys it, they don't really care. Now, Walmart's a hyper-rational actor, so they're not going to buy if they don't think they can resell. But the fact of the matter is, it doesn't matter how many retail sales take place, the manufacturer is satisfied as long as there are wholesale sales to Walmart. And that's the real distinction between some of the examples that David is giving as two-sided markets versus the standard retail model, which Walmart really takes to the extreme.
And just one last point is, where this matters in an antitrust, from an antitrust perspective as well, is the importance here, I think, is going to turn on the more two-sided markets you have, the more you sweep in this requirement of considering both sides at the first step of the antitrust analysis. So the plaintiff's burden to show a prima facie case of anti-competitive effects, which is ultimately what Amex held they couldn't show, right? So if it was one market, you would say, oh, they showed anti-competitive effects. Now the burden shifts to the defendant to show pro-competitive benefits. So while from an economic perspective, you're weighing the same factors at both steps of the way, the importance of putting it in two sides from a defendant's perspective is the burden is all on the plaintiff, right, to come up with that first. And I'm certain I know we're at a class action conference, but if we were at a summary judgment conference, I would say I'm certain you're going to see a lot of summary judgments saying they haven't met their burden because all they've shown is a price increase and they haven't established material facts on whether there was actually a loss or not.
Okay, I think we are out of time. So thank you guys very much.
Thank you.
Thanks all. That was great. That was likewise.
Well, just to bring the today to an end, I just had a few thoughts that I wanted to share as we're packing up. So I think one of the real values to this conference, as opposed to other conferences which many of us might attend, is that it really does bring together folks from both sides of the V. I can think of a number of conferences that are widely regarded as defendant-oriented conferences, or I can think of a lot of conferences that may be regarded as plaintiff-oriented conferences. But when I set out to plan a number of the panels for this conference, I intentionally wanted to make sure that both sides were adequately represented, that there were plaintiffs' and defendants' voices on every panel. And I think that really showed through. I think that in a number of instances we had real areas of disagreement, but I think it helped to sharpen our understanding of the issues that we discussed. And another thing that really dawned on me about midway through the conference was just how many different firms participated today. So at one point during the day, I opened up the pamphlet and I just started to count how many firms were here. And I think there were over 20 firms that participated. So I think around 17 law firms and 3 service providers. And they were pretty evenly split, again, between the plaintiff and the defendant side. So I think that's really a tribute to the conference and the conference organizers that this sort of conference exists. And so I want to extend a huge thanks to everyone who spoke today, everyone who put in some time ensuring that this was such an excellent conference. And I just wanted to give my own personal thanks to one of the prior panelists, David Kaplan, that I am at the point in my career where I am just starting to be retained as an expert on class certification matters. And I had an attorney just this week note to me, Jeff, you seem to be so well steeped in the arguments of class cert. And a lot of that is a tribute to the mentoring I received from David. So thanks a lot. And, you know, my passion for class actions, I hope, showed through in terms of my planning of this conference. So just as a reminder, there is a cocktail hour and dinner upstairs, so the same place where we had lunch, and I think it starts right now. So for all of you who have some extra time this evening, please come up and join us. There is, but I would be the wrong person to talk to about that. So it would be either Peter or Bernard in the back of the room would be the right people to ask that of.
Thank you.